Datar sir. Skin.
Sorry, my lord.
Not
We are getting bellicose.
It's indecent. Apart from anything else, it's indecent. You are not.
Mr.
You seem to be
Datar
not
won't do anything
practicing
like
here.
that, you know.
No, Mr. Datar would never do that. I'm saying him. I'm calling him.
Reply to so many points.
Whenever I argue, that's what he does. So I said it's indecent.
Not Mr. Datar.
No. He would never do it. He would never do it. No, he seems to be not practicing here. Just as a younger brother, I'm telling him not to do this. It's anywhere, before anyone.
Mr. Just say sorry to the solicitor.
No, it's not valid in an anger or something.
Right.
This happened fifth time, so
Right.
sixth time I just couldn't resist.
He's apologized.
No, that's okay. That's over.
Not only according to me, according to parliaments after the amendment, once the liquor is removed from my factory, then it comes under parliamentary control. Once it is purchased by the paint factory for making a paint or purchased by a perfume company or by somebody else, I have no control over it. UP government has no control over it. But I'm just giving, suppose for example, I decide, so as a legislative policy, I want to maximize my revenue. I'll say we are not allowing denaturing. Everything should be cleared for IMFL. I can do that. Take Bihar, they'll say no clearing for IMFL, only for industrial purpose because there's prohibition. So right up to denaturing is the state subject. And let us not dilute that is my humble request. I'll come to the next point on Tika Ramji, my lord. I just wanted to say that in the Para 32 observation, basically Tika Ramji UP Sugarcane Act was to be ultra virus, IDR Act and Essential Commodities Act. In Para 32, they say even assuming, if your lordship sees my submission, written submission which I
That you
give.
made the point, even assuming.
Yes, even assuming. I'm saying it is not obiter. It is Article 141. What Justice Bhagwati is saying is, even assuming 18G is there, unless there is a notified order, the state's power is not taken away. It is not obiter. It is a ratio decidendi. Obiter is something which doesn't fall for consideration. And just it's a passing observation. Now, further, Tika Ramji has been accepted to be correct law in Belson, 5 judges, and 3 other cases. That's in my written submission. I've given those 4 cases. So, Tika Ramji's observation that unless there's a notified order, 18G doesn't operate is Article 141, good law, not obiter. Now, just see the Industrial Disputes Act in the IDR Act for a minute, and I'll just close my submissions.
Then alcohol can be made from any feedstock which has high content of carbohydrates such as sugarcane, rice, maize, potato, beetroot, etc. In India, alcohol is predominantly made from sugarcane juice, molasses, a byproduct of sugar production, broken rice, damage of food grains, and maize. Major types of alcohols are given below. Rectified spirit. Rectified spirit generated after distillation out of those raw materials, having minimum 95% ethanol content is used only for industrial purpose. It is used for industrial purposes such as users as solvent in paints, industrial chemicals, etc. Then extra neutral alcohol, ENA. This neutral spirit having minimum 96% ethanol content is made by further purifying the rectified spirit. This is used both for potable alcohol and industrial purposes.
Mr. Solicitor, just
only a minute more.
No difficulty. Otherwise, I'll forget the question.
I'm sorry.
Now, extra neutral alcohol, ENA. You say that this is neutral spirit having a minimum of 96% ethanol content, which you produce after further purifying rectified spirit. Then you say this is used both for potable alcohol and industrial purposes.
For making potable, no? It should be for making. It comes
used for making, right?
Yes.
Now, in that case, at the point when ENA is cleared, is the stage of removal takes place, and it is removed for the purpose of the manufacture of potable alcohol.
IMFL.
If you don't mind.
IMFL, that is, right? It is being removed at the stage of removal. Why is it being removed? It is being removed for use in the manufacture of IMFL.
Potable, yes.
Will not that fall within the domain of the state? If it is removed at the point of removal for industrial purposes, we want you to respond to it. We want clarity on it. At the point of removal, if it is being removed for industrial purposes, certainly then it doesn't fall under entry A. But
not for the simple reason that extra neutral. Now, my lord, this is, my lord, a product which I purchase. If I am the IMFL manufacturer, I purchase that product. And thereafter, my lord, the third category of alcohol is absolute ethanol.
See, just
Also,
one second. But the person, solicitor,
Would you not-
your point therefore appears to be that it is only IMFL which falls within the purview of entry 8. Because that is the only thing which classifies as potable.
potable alcohol which can be consumed as
Sure on that. There's a little bit of we're not sure on that because at the stage when ENA is removed for the purpose, ENA is capable of being used both for potable
Industrial
liquor, right?
for
Now,
making
what
potable.
happens? What happens if you have, say, somebody whose business is dealing in ENA is removing it for the purpose of potable alcohol, namely for IMFL? Can you say that then it will not fall within the purview of entry 8?
Yes, ma'am. May I say the
In your
difference?
submission, it will not fall in the stage of entry 8 until IMFL is manufactured. I'm not sure that's the correct position.
May I show the difference according to?
Yes.
No, just one second.
Yes.
So is it your case that ENA will not be covered by entry 8 and only IMFL is covered by entry 8? Is it your case
Yes.
specifically?
Yes. Lord, number two, why it is? ENA can be used as it is for other purposes like, my lord, industrial purposes, etc. ENA cannot be used as it is as a potable alcohol. And if you have to undertake some activity or some process to make it potable, that is the distinction. ENA as it is used for, my lord, polish industry, etc., etc. My lord, there are several industrial uses. In this context, please see page 53, the chart. Page 53, my lord, for my satisfaction. Have a look at page 53. This is how it happens. Lord, molasses, sugar syrup, or grains. This is the raw material. I'm very clear about it. For any process which is subsequent, this is the raw material. Then preparation, that is adding water and enzymes for fermentation plus grinding in case of grains. Then, my lord, comes fermentation. My lord, Justice Oak has the.
Yes.
Then comes fermentation, that is time taken up to 72 hours. Then comes distillation, means to remove water and impurities to get pure alcohol. Then, my lord, we get either of these three things, my lord, depending upon the nature. Absolute alcohol, rectified spirit, only to be used for industrial purposes such as paint, chemicals, etc. Then upon further purification of the RS, it becomes extra neutral alcohol.
Now,
From-
you got it. Now, for the purpose of my question, are you all on the same page, page 53 of the
Yes,
chart?
but then-
Now, just one second. Look at the right-hand side of your chart, and the three. Upon further purification of rectified spirit, ENA, extra neutral alcohol, minimum 96% ethanol, BV. Now, there are two branches. One, industrial use depending upon market conditions or alcoholic beverage. So your contention is that until it becomes an alcoholic beverage, even at the anterior stage, it falls outside the purview.
Not the
I
middle
mean to
box
say-
wrong. Rectified spirit only for purposes is fundamentally wrong. The middle box. Rectified spirit only for industrial purpose. That is wrong. Because rectified spirit is primary distillation. It can be both. In the old days, rectified spirit was used for country liquor at 26% dilution,
Oh, that
32%
is, my lord, a
dilution.
hooch.
Now with advanced technology, it is ENA. So it is distillation, RS, ENA. But RS for industrial purpose is fundamentally wrong, which is the same error which synthetics made.
No. Synthetic doesn't go into this.
No.
Lord,
Synthetic says RS is equal to
Lord,
industrial alcohol.
kindly, my lord,
This box is wrong.
my lord, rectified spirit is used. It's very, very hazardous. My lord, this is what the hooch tragedies come. Rectified spirit can be used, but its use is a wrong word. Abused. My lord, there are certain elements, my lord, which are mixed.
Sure.
And my lord, when I say depending upon market conditions, my lord, sometimes the requirement of industrial use, my lord, only two more minutes. My lord, industrial use, when I say depending upon market conditions, some, my lord, depending upon the market condition, from the ENA, they make more, my lord, ENA, if the demand is more, otherwise it goes into making of Lord, on the basis of use, Lord, your lordships may not, Lord, define the term. The definition is, it can be capable of being converted into many things, Lord. Lord, rectified spirit is used in making not just country liquor. The hooch also, Lord, the hooch
All
tragedy.
right, we now got yes, Mr. Datta, what do you have to say?
I'll gather to.
And, my Lord, my apologies to my friend, my Lord, but I got irritated on the sixth occasion,
All
my
right,
Lord.
all right.
That's all.
All right.
Lord, quickly, my Lord. So, Lordship, I recommend Balsara should be accepted. And para 74 and 77 of synthetics, where they distinguish Balsara on the ground that they did not comprehend industrial use, is not a ground to overturn Balsara. Balsara, consistently, the application of Balsara had created certainty. Synthetics creates uncertainty. I would pray that your Lordship restores the Balsara provision. Secondly, my Lord, my submission is intoxicating liquor is an exclusive state subject, not subject to anything. And I want not subject to parliament. The word subject to is not there. So, my lord, ultimately there are 40 entries in the state list today.
We'll just take it down. Because we are,
Go for 5 minutes.
yes, certainly.
40 entries in the state list. And out of the 40 entries, 13 entries are subject to list 1 or list 3. So, virtually, out of 168 legislative entries throughout, general entries, I'm not including tax. Out of 168 general entries, there are only 40 in the state list. And out of 40, 13 are subject to either list 1 or list 3. So only 27 are left to the states. So my humble submission is, entry 8 should be interpreted to preserve the state's legislative competence in its widest amplitude. When the solicitor, I was just thinking to myself, just a thought came to my mind.
According to you, admittedly, even according to your position, would be outside the field of entry 8.
Outside entry 8,